Get ready for the dictation. Start. In the Principal Act, after section 147, the following section shall be inserted, namely, power of appellate court to order payment pending appeal against conviction, notwithstanding anything contained in the Code of Criminal Procedure 1973 in an appeal by the drawer against conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be a minimum of 20% of the fine or compensation awarded by the trial court, provided that the amount payable under the subsection shall be in addition to any interim compensation paid by the appellant under section 143A. The amount referred to in subsection 1 shall be deposited within 60 days from the date of the order or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the appellant. The appellate court may direct the release of the amount deposited by the appellant to the complainant at any time during the pendency of the appeal, provided that if the appellant is acquitted, the court shall direct the complainant to repay to the appellant the amount so released with interest at the bank rate as published by the Reserve Bank of India prevalent at the beginning of the relevant financial year within 60 days from the date of the order or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complainant. From both the provisions quoted above, it is apparent that power vests with the trial court as well as the appellate court from directing the drawee to pay interim compensation to the complainant up to 20% of the value of check. The interim compensation by the trial court can be granted at the stage where the accused felt guilty or upon framing of charge. Thus, there are two stages where the interim compensation can be granted after the period of 60 days and further extending by 30 days may be directed by the court. The section 143A as well as 148 makes the provision directory and mandatory. In the case of Salim Advocate Bar Association versus Union of India reported in 2005 6 SCC 344, the Supreme Court held as under the use of the word shall in order 8 Rule 1 by itself is not conclusive to determine whether the provision is mandatory or directory. We have to ascertain the object which is required to be served by this provision and its design and context in which it is enacted. The use of the word shall is ordinarily indicative of mandatory nature of the provision, but having regard to the context in which it is used for having regard to the intention of the legislation, the same can be construed as directory. The rule in question has to advance the cause of justice and not to defeat it. The rules of procedure are made to advance the cause of justice and not to defeat it. Construction of the rule or procedure which promotes justice and prevents miscarriage has to be preferred. The rules or procedure are handmaid of justice and not its mistress. In the present context, the strict interpretation would defeat justice. In the case of Kailas versus Nanku and others reported in 2005 4 SCC 480, the Supreme Court held as under. We sum up and briefly state our conclusions as under the purpose of providing the time schedule for filing the written statement under Order 8 Rule 1 of CPC is to expedite and not to scuttle the hearing. The provision spells out a disability of the defendant. It does not impose an embargo on the power of the court to extend the time. Though the language of the proviso to Rule 1 of Order 8 of the CPC is couched in negative form, it does not specify any penal consequences flowing from the non-compliance. The provision being in the domain of the procedural law, it has to be held directory and not mandatory. The power of the court to extend time for filing the written statement beyond the time schedule provided by Order 8 Rule 1 of the CPC is not completely taken away. Stop.